Be ready. 5 seconds.
At the outset, it is necessary to observe that although, in the initial stages, the respondent had raised an objection regarding the maintainability of the present petition, however, no such contentions or objections challenging the maintainability of the present petition were advanced at the time of final hearing. It is, thus, not necessary to examine the same. There is considerable merit in the contention that there is no material on record, which even remotely establishes that the appellant is guilty of an offence under Section 9(1)(b) of Foreign Exchange Regulation Act. In order to establish the commission of an offence under Section 9(1)(b), it would be necessary to establish that the appellant had received payments by order or on behalf of any person resident outside India and through any person without corresponding inward remittance. In the present case, there is no such evidence or material whatsoever that indicates that the appellant had received any amount by order or on behalf of any person resident outside India. No such evidence or material has been placed on record. The original order dated 17/2/2014 passed by the adjudicating authority does not even mention the name of the persons from whom the appellant is alleged to have received any funds. The prosecution's case is that the appellant had received certain funds from Satish Kumar Sharma, who, in turn, had received certain funds and had distributed the same. In order to establish this offence, it would be necessary for the Enforcement Directorate to have produced material to the effect that Satish Kumar Sharma had made payments to the appellant by order or on behalf of a person resident outside India. The original order was passed by the adjudicating authority solely on the basis of an alleged statement of an employee of the appellant. He alleged that he had received a sum at the instance of a person resident in Dubai. However, there is no material brought on record to establish the person who had delivered the said amounts. It is important to note that the tribunal proceeded on the basis that the appellate authority had imposed a penalty without taking into account the statement. Further, it is also apparent that the said statement was not corroborated by any credible material evidence. In Vinod Solanki versus Union of India and another, 2008, 16 SCC 537, the Supreme Court held as under, it is a trite law that evidence brought on record by way of confession, which stood retracted, must be substantially corroborated by other independent and cogent evidence, which would lend adequate assurance to the court that it may seek to rely thereupon. We are not oblivious of some decisions of this court wherein reliance has been placed for supporting such contention, but we must also notice that in some of the cases retracted, confession has been used as a piece of corroborative evidence and not as the evidence on the basis whereof alone a judgment of conviction and sentence has been recorded. The Supreme Court had held that the voluntary nature of a statement is sine qua non for the authorities to act on it. The court had also explained that merely because a statement is retracted does not mean that the said evidence was unlawfully obtained, comma, however, comma, the court intending to act on such statements as being voluntarily made, comma, is required to apply its minds. Stop.